Let's talk about Vehicle Code Section 23152A. This is driving under the influence of alcohol or drugs, or the combination of alcohol and drugs. In order to convict you of this offense, the prosecutor has to prove that you were operating a motor vehicle under the influence, and under the influence is defined as a state where you do not have the skill and caution characteristic of a sober person. In making their case, the prosecutor will generally point to 5 types of evidence. First is the driving pattern. If you were weaving, if you were in an accident, if you were driving erratically, then the officer or other witnesses will testify about that. The second is what we call objective symptoms of intoxication. So that is a flushed face, red bloodshot eyes, the odor of alcohol, slurred speech, what's sometimes called an unsteady gait or an unsteadiness on your feet. Third is the performance on the field sobriety tests. Fourth are sort of statements or admissions that you made out in the field. So if you told the officer, I do feel kind of drunk, I did have a lot to drink, I know I shouldn't have been driving, then usually they can introduce those statements against you. And by the way, it's a very bad idea if you're ever detained for DUI to make statements like that to the police. Finally, fifth is the results of the chemical test. So the reading on the blood or breath test.